Jefferson County Court, Law number 2 is back in session. The court is in session with the jury trial docket, the announcement document, and the pretrial conference docket. First case is on our pretrial conference docket. It's cause number M327-800. Case is filed in the state of Texas versus Brian Orlando DeLeon Norris. Mr. Brian Norris was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court really called the name of Byron Norris at the courthouse door. I think his first name is spelled Bryon. And Mr. Norris did not answer. He's not appearing in court since the court has been in session. The time now is 1:53 p.m. on today's date, June 10th, 2024. Ms. Bailiff, would you please call the name of Byron Norris?
Yes. Norris. Byron.
Let me do this in my call. I think he might pronounce it Brian. Brian.
I think it's Byron.
It's not an R in it.
Oh.
It's Bryon. It might be Brian. Might be Byron. Brian. Bryon.
Oh.
It might be Byron. Call Byron Norris at the courthouse door. Byron Norris.
I said Byron.
I thought you said Byron. It's not with an R. It's not Byron. It's Byron. Byron Norris. Byron Norris. Brian Norris. Brian. Bryon.
You just confused me.
It's Bryon.
Is it Brian or Byron? I like Byron.
It sounds like Brian.
I said Byron. Byron.
No, it's more like a Brian. Bryon. It's like Brian. 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 Brian Norris. Brian Norris. Brian Norris. Brian Norris.
And this is dope. No. Brian.
Let's go out there and call Brian Norris. Brian.
We're all sure.
Yeah, just the way it's spelled. It could be misspelled.
How many attorneys does it take?
It could be misspelled.
Happened before.
Brian.
Yes, happened before.
Brian.
No response, them jurors are cracking up at me right now.
Okay, no. Okay, Brian Norris has not answered. His name was just called again at the courthouse door. The time now is 1:56. He has not appeared in court since the court is in session. He has been given a reasonable time to appear in court. He has not appeared in court. State, do you have a motion? That motion will be granted. Byron Norris bond will be forfeited and the warrant should be expressed arrest and cause number M327-800. Next case is cause number 24-CCCR-0946. Case is filed in the state of Texas versus Ryan Shan Romero. Romero. Brian Shan Romero. Brian Shan Romero was scheduled to be in court this morning at 9 a.m. At about 9 a.m., Brian Romero's name was called by the court bailiff at the courthouse door. Brian Romero did not answer. He has not appeared in court since the court has been in session. The time now is 1:57 p.m. on today's date. Ms. Bailiff, would you call the name of Ryan Romero at the courthouse door?
Brian
Romero.
Romero.
Yes.
Brian Romero. Oh, no response, Your Honor.
Okay, no response. Ryan Romero's name was just called at the court out the door. Ryan Romero did not answer. Reasonable time has passed to give Mr. Romero an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Statement of bond forfeiture.
That motion will be granted. Ryan Romero's bond will be forfeited and a warrant shall be issued for his arrest. Okay. Do we have, Ms. Bouchon's waivers on file? Notice subpoena. Okay, Miss. Oh, that's, they did that over in the other court transfer order. Here it is. Waiver of counsel. State, are you ready?
Yes, Your Honor.
Defense, are you ready?
Yes, Your Honor.
And just for the record, Ms. Bouchon, in both of these cases she's pro se. I do have a waiver of counsel for purposes of entering guilty plea or proceeding to trial that was filed on January 4th of 2023. It is signed by Ms. Bouchon, Ms. Karen Bouchon. Is that correct, Ms. Bouchon?
Yes, sir.
Okay. Now, before we get started, not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the range of punishment, the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and a state jail felony. State jail felony, for a person convicted of state jail felony, range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, range of punishment minimum 2 years to a maximum of 10 years in the state penitentiary, and they can get a fine up to $10,000. If a person is convicted of a second degree felony, which is higher than a third, the range of punishment is minimum 2 years to maximum 20 years in the state penitentiary, and a fine of $10,000. Person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, we don't handle those type cases. The type cases we handle are the class A, B, and C misdemeanor. Now, we start at the top, it's a class A, then we go down to a class B and a class C. And the difference between those offenses are the range of punishment. And the range of punishment for a class C misdemeanor is a fine only. A person will be only given a fine. The fine cannot exceed cannot exceed $500. A person is convicted of a class B misdemeanor, the range of punishment minimum 0 days to a maximum of 180 days in the county jail. A fine from $0 to $2,000, or they could be given both such fine and confinement. The person is convicted of the highest misdemeanor, range of punishment is minimum 0 days to a maximum of 365 days in the county jail, or a fine from $0 to $4,000, or they could be given both such fine and confinement. Now, case that we have here is a case that was appealed from a city court, and so it is a class C because city courts, municipal courts, and JP courts, they only handle class C misdemeanors. And so when a person appeals, it comes up here. And so we're here on the class C misdemeanor. Now, you will be examined for inclusion in this criminal case. Our court hours normally vary from 9 a.m. to 5 p.m. However, in County Court at Law number 2, we usually have large dockets in the morning. Sometimes we do not get out of court until 1:30 or sometimes a little later. And so what we normally do here is we have our trials in the afternoon starting at 1:30, and then we take recess at 5 p.m. Now, you should be mindful that if you're selected as a juror on this case, you are serving or performing a significant service that only free people can perform. If you're selected for inclusion on this jury, this case will be tried expeditiously, consistent with justice, which require a careful and impartial consideration of all the facts and the law in this case. Now, if selected, you will be permitted to separate for meals. You will be permitted to separate for recess, and you will be permitted to separate at night. Now, there's a administrative function that I must perform. Actually, there are 2 administrative matters that I must perform. I will perform the first administrative function now, and that is I need everyone to raise your right hand. And then after I give you the oath, please say, I do. Okay. Now, do you and each of you do solemnly swear that you will make answers to such questions as may be propounded to you by the court or under its directions, touching on your service and qualifications as a jury, so help you God? Please say, I do.
I do.
Okay, you may put your hands down. Now, the law requires that each of you must possess certain qualifications to serve as a juror. Also, there are certain excuses and exemptions that a person may wish to claim. First, I will determine whether or not each of you are qualified to serve as a juror in this criminal case. It is very important that you answer each question truthfully. Now, if you do not, and the lawyer or I discover that fact after you have been seated as a juror, the case could be retried. That is, it'd be given a mistrial. And you may be held in contempt of court. That is, you can be placed in the Jefferson County Jail for up to 6 months, and you could be given a fine up to $500. Now, the way that I'm going to ask the questions, I'm not going to ask each question individually. I would ask one, I'm going to ask the questions in a group. And when I get to the last question, I would ask, is anyone disqualified under the law? If you think that you may be disqualified under the law, you could just simply say, just simply raise your hand. And once you raise your hand, we're going to ask that you will come up before the bench so that we can discuss the matter more privately. And when I use the term more privately, what I mean is, now, first of all, you should be aware that we are airing on YouTube. So we'll turn the YouTube off. We'll turn the microphone off. Turn it back on. And we have a noise sound device. And then we'll ask you to come up before the bench so that we can discuss the matter more privately, where other members of the jury or the panel cannot hear what we are discussing. Okay. Now, again, I will ask the question. I just need you to answer the questions to yourself. You don't have to answer it out loud. When I ask the question, you just think about it. And then we're going to go to the end. You're going to think about each question. If there's one that you think that you may be disqualified for, at the end, you just simply raise your hand. Now, the first question that I will ask is this. Except for failure to register, are you a qualified voter in Jefferson County and the state of Texas under the Constitution and laws of this state? First question. Next, have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause at this next question because I have to explain to you that the question I'm going to ask, I'm not trying to pry into your own personal affairs, but it's a question that I'm required to ask by law. And the question is, are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 6 months in a county court, or 6 days in the preceding 6 months in a district court? And that was the last question. So Next question is anyone disqualified under the law? If you think that you may be, just please raise your right hand. Let the record reflect that no one on the panel raised their right hand. Now I will proceed to exemptions. I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these exemptions apply to you, but you still desire to serve as a juror, just remain seated and you do not have to raise your hand. Now, if one of the exemptions apply to you and you do not want to serve as a juror, just raise your hand at the end of the questioning. And I will ask the questions in the same manner that I asked the questions when I had to determine whether or not you qualified. First question. Are you a person over 75 years of age? Do you have legal custody of a child or children 12 years or younger, and jury service would necessitate leaving the child or the children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher learning? Are you an official or an officer or employee of the Senate, House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petit juror in the county during the 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed to a location away from your home station and out of your county of residence? And that was the last question. Now, if any of these exemptions apply to you and you desire to exercise one of these exemptions, which will allow you not to serve on this jury, would you please raise your right hand? Let the record reflect that no one on the panel raised their right hand, so no one is claiming an exemption. Now, I will move to excuses. If any of you feel that there's a reason for why you cannot serve on the jury, based on the statements that I'm going to make, then you can just simply raise your right hand, and then I will ask that you will come before the bench and we'll discuss that matter more privately. Now, the way I'm going to handle the excuses, we won't be asking questions. I'll be making some statements, and then at the end of the 3 statements that I'm required to make, I'll ask if there's anyone who's here who's desired to claim an excuse, so that they will not be required to serve as a jury in this case, as a juror in this case. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, a juror cannot be excused for financial reasons unless both the defense and the state consents to them being excused. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel that wishes to claim an excuse? Let the record reflect that no one on the panel is claiming an excuse. Let the record also reflect that all the jurors are qualified. None of the jurors are claiming an excuse, and no one is claiming an exemption. Now, let the record reflect that the time now is 2:27 p.m. on today's date of June 10th of 2024. Let the record reflect that the panel is present in court. Let the record reflect that the state is present with Assistant District Attorney Andrew Hubel and Attorney Haley Simmons. Let the record also reflect that the defendant, who is pro se, Ms. Karen Bouchon, is present, and she is also present with her standby attorney, Attorney Marva Provo. Again, good afternoon, ladies and gentlemen. And as I mentioned earlier, you have been summoned to this court to serve as prospective jurors in a criminal case. The defendant, Ms. Karen Bouchon, she is pro se. And now, for those of you who do not know what pro se means, that means that she's representing herself. And now you see another person sitting next to her. That person is an attorney, and that's Ms. Marva Provo. She's there to assist Ms. Bouchon if Ms. Bouchon need any assistance in trying the case. The state, as I mentioned earlier, is represented by Assistant Criminal District Attorney, sitting first chair, Andrew Hubel, and sitting second chair, Ms. Haley Simmons. The court reporter, in this case, is Ms. Ada Christie. She will be taking down everything that's being said. So speak up when you are answering or asking questions. The bailiff is Ms. Brenda Mosley. I think you've met her already. And in this case, Mr. Hubel, the information, not the information, but the docket sheet says that Ms. Bouchon is charged with a traffic offense, but I don't think that's necessarily the charge, right?
That's correct.
Okay. So what is Ms. Hubel being charged with?
Ms. Bouchon is being charged.
Bouchon, excuse me.
A declaration of dangerous dog.
Declaration of dangerous dog?
Yes, Your Honor.
Okay, and that is a Class C misdemeanor?
That's correct.
Okay, so Ms. Bouchon will be being charged with a Class C misdemeanor, declaration of a dangerous dog. And as I mentioned earlier, a punishment range for a Class C misdemeanor is by fine only. And in this case, I think the state will mention to you what the fine range would be. Now, the state and the defendant through their, the state and the defendant have a right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, say so, and I will ask you to come up to the bench so that we may discuss the matter more privately. Is the state ready to proceed?
State's ready, Your Honor.
Is the defense ready to proceed?
Bench ready.
I'm going to keep time. And we'll allow each side 30 minutes. Now, if you need additional time, just ask me to give you additional time and the court will allow you additional time.
Thank you, Your Honor.
Okay? So at this time, Mr. Hubel, the panel is yours.
Good afternoon, everybody. Is this a good volume? Can everyone hear me? All right. Thank you. So the part of the trial that we're at right now is jury selection, otherwise known as dire, which means to speak the truth. Essentially, what we're asking you to do for us is to give us honest answers to our questions so that we can tell if you're a proper juror for this case. We only ask you to just tell us the truth. That's all we do. So, as a introduction, judges introduced all of this at this point. Do you know any party involved with this case personally? No one knows anyone here? Okay. And that includes the Honorable Judge, Terrence Holmes. Good. As we were, as the judge was saying before, this is a Class C misdemeanor. It's punishable by fine only. Now, with it being a Class C misdemeanor, the scale the judge was talking about earlier, starting with the highest felonies and the lowest misdemeanor. This is the lowest misdemeanor in total, but it's also in and of itself very important too, because each individual, each defendant, like what's been shown here, deserves a day in court. Can we all agree on that? Now, this specific Class C misdemeanor that we're talking about is a declaration of payments, and specifically, this will be defined in the New York City ordinance, which is derived from the Health and Safety Code. Now, as an opinion question, start with you, Mr. Magana. What do you think makes a dog dangerous?
I believe a dog is dangerous if it's not on a leash and it's harmful to others. If it's not trained correctly.
You said harmful to others. Would that for you include harmful to just people or harmful to people and animals, other animals?
People are not animals.
Okay. Now, is that Mr. Galani? Okay. Why would you say, in your opinion, or well, let's start with this. In your opinion, is an ordinance like this important? Okay, why would you say so?
So you'll have dogs on leashes.
And that's in order to prevent. And that's in order to prevent.
Attacking other people, right?
Okay. So this is a question for everybody. And first of all, on the slide, it's a picture of my dog Jake. He's a beagle, but back in, he was a beloved member of the family. So what I'm going to ask all of you is, how many of you are dog owners? Okay. Does anyone want to talk about their friend? Any volunteers? Okay. Can I see those hands one more time? All right. Ms. Bates, can you tell me about your dog?
I have two dogs. I have a German Shepherd mix and I have a Bruno's Bristol. They're great dogs.
Jake was a great dog too. He actually passed last year.
Sorry.
He lived 18 long and happy years. So basically, my point with that is that a lot of us know what it means to love dogs like members of the family. They're very important to us, and I don't take that lightly when prosecuting this case. But that comes with important questions. Ms. Bates, knowing that, there is there are dogs in, as a subject matter of this case, do you think you can be fair and impartial?
It's kind of hard for me, because I'm kind of going through the same thing as she is, the animal control said that one of my dogs got out, but they didn't get out. And I'm actually fighting the case now, I go back to court on July 25th, so I don't know how I would feel about being a juror on this case.
So you don't think,
Because I know my dog didn't get out, I had proof, I have my niece as a witness, and they still take me back up there, so I don't know.
Yes. So, Ms. Davis, based on that, do you think that you could not be fair and impartial in this case, just due to the fact that it could be similar to yours?
Yeah.
I understand. Is there anyone else who feels that they could not be impartial based on the fact that there is a dog involved in this case? No one else has raised their hand, and, thank you, Ms. Davis, for your honesty. But, one other thing that I want to ask is, can we all agree that dogs have the potential to be harmful to to humans or other animals? Does anyone disagree with that? No. Another subject, like we've been discussing, like I've been discussing with Mr. Lalonde, the purpose of this ordinance is to prevent, animal attacks. So is there anyone here who, either themselves, a friend, or a family member, has been the victim of such an attack? See, this juror number 4, Ms. Bates, juror number 11, Mr. Hankemer. Am I pronouncing that correctly? Yes, sir. And juror number 14, Mr. Crawford. So, starting with Ms. Bates, can you tell me a little bit about that? And if you don't feel comfortable doing so, we can speak later outside the presence of the.
Okay, it was actually my daughter, the neighborhood I live in, I think people drop dogs all the time, and she was out riding her bike, and a dog chased her and bit her leg, and she fell and scraped up her knee.
And did anything happen with in
No,
that case?
I mean, they didn't know who the owner was, and,
Thank you. Mr. Hankemer?
It was my neighbor's dog, and, I had issues with it, coming over my property and growling and being angry, I guess you'd say. And, one day I was out working, cutting brush, my trees and brush on my property, and it snuck up behind me and bit me. And, I called animal control. They came out, and there had been some, other neighbors that had issues with this same dog, and they eventually had to get rid of it. Either, I think it was, have a insurance policy to cover it or put it in a fence. And, next thing I know, it was gone, so.
Thank you. And Mr. Crawford?
Turned my back on a blue healer and he let me have it.
Was it a neighbor's dog, or do you know?
Oh, it was a acquaintance's dog, yeah.
Okay. And did anything happen with that case, or?
No.
Okay. So I'm going to, ask you three, the same question. Based on your experiences, do any of you think that, you would not be fair and impartial in this case based on that? So y'all all think that y'all can still be fair and impartial?
Yes.
Okay. Now, moving on to discussing the actual ordinance, this is pretty verbose, so I'm just going to read it to you. So this is New Orleans, Texas Code Ordinance, Section 10-26A, Declaration of Dangerous Vicious Dog. The animal control officer or local refuge control authorities may declare a dog to be a dangerous or vicious dog if the official has sufficient cause to believe that the animal is dangerous or vicious. which begs the question, what does dangerous or vicious mean for the ordinance? So, for the purposes of the, prior section code of ordinances, the term dangerous or vicious dog means that a dog, has attacked or shows the potential to inflict serious injury or death to a person, or bites a person other than the owner without provocation on public or private property. And then 3, has a known or apparent propensity, tendency, or disposition to attack unprovoked, to cause injury, or to otherwise threaten the safety of persons or domestic animals. Now, for the definition of the ordinance to be met, the state need only prove one of these. And addressing specifically, the word apparent propensity, the apparent nature of that propensity, tendency, or disposition can be derived by that conduct. And by that, I mean, it can be, you can decide if that propensity, tendency, or disposition exists based on the facts of the case, based on what the dog did. So to summarize, the state must show must prove one of these things beyond a reasonable doubt, that the dog has attacked and or shows potential to inflict serious injury or death to a person, or bites a person other than the owner without provocation on public or private property, or has a known or apparent propensity, tendency, or disposition to attack unprovoked, to cause injury, or to otherwise threaten the safety of persons or domestic animals. Now, does that make sense to everyone? Does anyone have any questions about the wording at this point? Does anyone have an issue with the fact that the state need only prove one of these for the definition of dangerous dog to be met? So I hinted at it just a second ago, but the state's burden is, in this case, is to prove the alleged conduct beyond a reasonable doubt. If the state succeeds in doing so, then you must vote guilty. If the state fails to do so, you must vote not guilty. So what's beyond a reasonable doubt? There's no legal definition. We can't give you a definition for beyond a reasonable doubt. Each individual must have their own personal standard for what beyond a reasonable doubt is. Now, one thing that the courts have given us is to say that it does not mean beyond all doubt. It does not require absolute certainty, but it does require you to, in your own personal believe that the conduct took place beyond a reasonable doubt. So the last statement that I put there is use your common sense. When evaluating the facts in this case, a good example, I think, is dealing with puzzle pieces. Now, from these 3 puzzle pieces, you can't really tell what the actual image of the puzzle is, right? Can you, Mr. Mann?
What the actual figure is?
Right. With those 3 pieces, you can't, can you?
Well, the one on the right to me seems to be a puzzle piece, the one on the right top, that has the possibility of another piece being attached to it. That is actually what it looks like to me.
Right, but with those 3 pieces, you can't tell what the whole puzzle is.
No, right, I can have.
Okay. Now, Mr. Williamson, with that, can you tell what the puzzle is now?
Of course.
Okay. It was
a gun.
and there are still some pieces missing, correct, from the image?
Mm-hmm.
But you can still tell what that image is, right?
Yes, sir.
You don't have any reasonable doubts that that image is of a pistol. Okay. And you can sort of see this as an analogy for what a criminal case is. There will be the pieces of the puzzle are evidence. There will be some that's missing, some blank spaces that you will, in your evaluation of evidence, have to fill in. But just like with this picture, once the state has concluded its case, We believe that you'll be able to tell the picture of the space beyond the visual data, what truly transpired. So on the subject of evidence, Miss Ross. Ms. Ross, what kind of evidence do you think you would see in a declaration of dangerous dog case?
Some evidence that the dog, attacked someone or showed teeth, bared, growled or, acted like he was gonna attack someone or something.
Yes. And what do you think the state would show to show the jury that happened?
Medical records, perhaps, photos, video, there's some kind of video recording. Maybe somebody wants, recording.
Can you think of, Ms. Williams, can you think of anything else that the state might bring to prove that, a dog is dangerous? What about testimony from the individual who's attacked?
That too.
And from law enforcement and animal control that responded? So here's some examples that we touched on in our conversation: video, photos, witness testimony, whether that be the complaining witness, who was the victim of the offense, or law enforcement and animal control. Now, during this case, it's important that you only take into account stuff that's been offered and admitted as evidence, or stuff that's been stated in testimony. So that's the evidence that you will be able to review when deciding guilty or not guilty in this case, essentially. On the subject of testimony, witness credibility, the state will be calling witnesses in this case. So I believe it's fair to ask Ms. Bass, how would you evaluate the credibility of a witness?
Story.
So you would have to listen to what they have to say, right? So regardless of the witness's occupation or how they look, you would not take that into account, but only base your credibility on what they said on the stand. Okay. And correct me if I'm wrong, but do you believe that that's the same kind of assessment that you make every day when talking to people? So essentially, whenever we call witnesses, whether it be state's witness or defense witness, regardless of what their occupation is, or where they come from, they all start off with the same credibility. And we all have to listen to what they say, understand, and evaluate their credibility independently. Can everyone agree to do that? And one more thing on the subject of witness credibility. So, Mr. Harris, let me ask you this: if one witness, let's say the complaining witness, the individual who's the victim of the case, got on the stand and established all the elements necessary to prove the case, and you believe them beyond a reasonable doubt, would you feel comfortable making that decision based on their testimony alone?
I mean, there are things there that I believe that it did happen, and yeah.
Okay. Is anyone uncomfortable about it? Okay. I did not see any hands raised. Okay, so turning back to the range of punishment one more time. Given the fact that this is a case involving animals, was anyone concerned, I guess, maybe about what would happen to the animal? If they were deemed dangerous? That's, Ms. Reed?
Mhm.
Well, the determination of a dangerous dog does not mean that you necessarily have to get rid of the dog if the dog is, put down or anything like that. What does happen is that you have to post signage. Dog has to wear a special collar identifying themselves as a dangerous dog. They have to be registered and they have to pay a yearly compliance fee. So if any of you are worried about about what would happen to any of the dogs in this case, their lives are not endangered. Just to put that to bed. So finally speaking about the jury's duty, what y'all do is y'all look at the case, y'all evaluate the facts, and decide what you believe, what you don't believe based on that evidence. You apply those facts to the law that will be given to you in the court's charge. You'll have all the law necessary to decide the case. And then in rendering a true verdict, in a unanimous verdict, you follow the law. In order to do that, you'll have to make a judgment call. Is there anyone here who, for religious reasons or otherwise, feels that they cannot sit in judgment of another? Okay. Is there anyone here who feels that during the duration of the trial that they would be unable to adequately pay attention to the facts? I don't see any hands raised. So, once more, just to review the law, the state must prove only one of these. The state must show that the defendant's dog either has attacked and or shows the potential to inflict serious injury or death to a person, or bites a person other than the owner without provocation on public or private property, or has known or apparent propensity, tendency, or disposition to attack unprovoked, to cause injury, or to otherwise threaten the safety of persons or domestic animals. Does anyone have any questions about this case, about the law surrounding this case? Or anything that you think I should have asked?
I have a question.
Yes, sir.
One of the bullet items on the last screen showed there said that, the dog bites someone on public or private property.
Right.
So if, this animal bit somebody in his own yard, that's grounds for this.
Under the ordinance.
Sorry.
Under the ordinance.
I'm All right. Thank you.
And does anyone have an issue with that? And nothing that you feel like, any burning questions that I should ask? All right, thank you all very much for your time. This is important to the justice system, and we would not be able to do this without you.
Ms. Buson, you may proceed.
Thank you. Good afternoon. Thank you all for being here. Council touched on a lot of important subjects, a lot of issues that I was going to bring up and ask questions on. There were a few that I had regarding the city ordinance that he had displayed on the screen. And the fact that there is 1 out of 4 within the city ordinance that he's has approved, just 1 out of 4. So I'll ask, Ms. Bates, wasn't it you that has an issue ongoing? Okay. So how do you feel about that issue going on? Is it, are you taking it personal? Is it something that's affecting your family? How do you feel about
I
this?
mean, it's really affecting me going back and forth when I know that my dog didn't get out the house. So just because animal control is mad at me because I kept reporting the lady next door, they rolled me up because the pit bull was loose, but it wasn't my pit bull because my pit bull should only even go out my house, but I tell her to. So That's just really irritating to me.
I completely
So I
understand.
have more lenience to be towards you than to be for animal control.
Okay, well, thank you for your honesty, and I'm sorry you're having to go through that.
Me too.
It's something that, you know, until you go through it, you don't understand.
Exactly.
Um, I do want to say that, to everyone, all the jury, when you get these copies of the city ordinances and the state statute regarding an animal, altercation or an animal incident, you'll see on the definitions how it defines on a human. Okay, in the health and state statute. And when city ordinance comes across, it will say, including domestic animal. Okay. And then you will read where it says, words like severe injury, propensity, knowledge, tendency, all words that describe a situation that has been known previously, if you all can understand the meaning behind these words. So I'll ask, let's go with Mr. Crocker. If you had knowledge of an animal that was bullying the neighborhood, you know, disagreeing with other animals in the neighborhood, would you ultimately report that animal before any action was taken, you know, like a fight or a chase or anything like that?
Possibly.
All right, then you say you were bit by your friend's
Yeah.
dog on your property? And you didn't report the incident? Is that something that you're still dealing with, or is it over? It's done?
So,
Were there any hard feelings about it?
no.
None? Um, let's see. I guess I really want to ask all of you, you know, dogs, animals in general are considered property. Okay, they have no value. However, each of our animals have values to us as caregivers, as part of the family. They're part of the family, okay? When there's a situation that comes about that is misconstrued and wrong and false, and it gets twisted by outlining sources, let's say. I want to know maybe from Mr. Harris. We've got to see all the facts before you came to a judgment, is that correct?
Yes, ma'am.
You would have to have every kind of evidence in front of you about why the situation happened, who did what, and you would make a decision based on that, whether or not it was, you know, incorrect or if it was a correct move.
Yes, ma'am.
All right. Okay, again, council has hit on a lot of subjects I wanted to, and for that I'm thankful. So once again, I did like the puzzle pieces that you put up there, where, and this will be a puzzle piece. It will be a puzzle piece that will have to have your direct attention, your guidance in your own informative decision-making process that you've learned throughout growing up with your own animals. Understanding what the facts of the case are, understanding what the evidence says, and seeing what is true and not true. Okay, there's plenty of reasons to believe that this is a non-important case. There's plenty of reasons to believe that this is just a dog on a dog, this is just a dog case, it's no big deal. Okay, but all of us that are dog owners understand the quality of life that they depend on, okay, because they give us life. because they make us feel good. Okay? And for that to be in question and for that to be, judged by someone that has no knowledge of any kind of situation, it can be hurtful. Okay, Ms. Bates, you were going through the situation. Is there anybody else? I haven't seen the other hands besides yours. Nobody else was going through a dog situation, nothing like that? Okay. Let's do Ms. Johnson. Have you ever witnessed a dog attack?
No.
Not on a person or a domestic animal, never seen it on TV, not in your neighborhood, nothing like that?
TV? Yeah, I was down on TV, but not in person.
Not in person, but on TV? How did that make you feel? I mean, did it raise you kind of like getting angry or? You know? You just watched it and then that was it? Was into it? Thanks. You don't have to use money. What kind of dog was it that you had the situation with? Or it was a pit bull, right?
But they said there was a loose pit bull.
Okay.
It's not quite the same situation.
Yeah, right. Okay. Okay. So I want to also hint or touch on the subject of maybe, let's say, my son is 14 years old and he's a big guy, okay? 200 pounds, football, big guy. And here comes another little dude down the line that's, smaller guy, about, I don't know, not so big, maybe 140 pounds. My son's almost 200 pounds. And the size difference could mean a lot of the weight would shift to, the bigger person maybe getting an upper hand, okay? And I'm saying this to say that maybe dogs' sizes, when it comes to a altercation, an incident, could possibly lead into a defensive mode. It could lead into like a pack within a pack, if you all have heard anything in that respect. So, the size difference is something that if you're a big one and then you have a little one and there's an altercation, 9 times out of 10, the big one's gonna get blamed for the little ones, little bruises and cuts and scrapes and stuff like that. It's just, the way it is the way it is. So, and we'd like you all to keep that in mind when you hear about all of the evidence and facts that come through. Because there will be exhibits of pictures of my animals, and I'm assuming, the plaintiff's animals as well. And you all will see the size difference, and you all will see and understand, what the real issue is. Let's do, I'm sorry if I mispronounced this. There was something I was looking at, here it is. I'll just say first name. Mary Denise? So there you go. Okay. All right. Have you owned any dogs? No. And they were your family pets? They were family animals, you did everything for them? Have they ever been bitten? Has there ever been any kind of altercation with your dog and another dog?
Yes,
What happened?
it was, we were living out in Delos, and a lot of people, big yards, nobody, I said, very few people
Mhm.
have their dogs on a leash or have their dogs. And there was just a dog in the street that every time he walked down the street, he'd come up the driveway, and my shepherd and this dog would, have a few words, and yes, they did go ahead.
And it was just a stray dog that was hanging out?
It was a neighbor's dog.
No, it was neighbor's dog. Okay. But he was out all the time,
Yeah,
because it's country living, huh?
he was just kind of a bully, I guess you'd say.
Yeah, no. So whatever happened in that situation, did he go away, or is it good now, or
Well, this has been many years ago.
many years ago?
Yeah, so
So they got into it a couple times, or just once or twice, or?
there were a couple times, the
Couple
dog
times.
returned and come up the driveway. And my shepherd was out.
Yeah.
It was nothing serious, no blood, no anything. But, that dog,
As far as you know, there was an owner attached to it. Oh, well, I mean, it was a neighbor's dog, was that? It's a neighbor's dog. Okay. Um, so as the evidence is gonna be presented, come to the real question of reasonable doubt. And that means, reasonable doubt of the evidence, the facts that's presented. You will see a video, you will hear testimony, you will see words written down, and see ordinances, health state, state statutes. And beyond reasonable doubt means just what it means. If there's even a shadow of doubt that this altercation was something different than what is reported, then you, of course, have to prove, or you have to say not guilty. Because beyond a reasonable doubt means just that. It has to be proven, and like counsel said, only one of the four. Okay, and there's going to be four elements, and there's going to be four reasons why you can either say guilty or not guilty. All right, you just have to prove one. All right, and reasonable doubt lingers on right there. Reasonable doubt is right behind all of the evidence and everything that you're going to see. So I'm comfortable with you all understanding what the facts are, what the case is about, what you all are going to ultimately, have a decision to make on. And I don't take it lightly, just like counsel. This is not something I want to be up here doing. Okay, I'm a landscaper by trade, not an attorney. So I'm up here defending my dog because that's what I feel is the right thing to do. Okay, it's up to y'all to decide whether or not that's the right thing for them to do. Meaning the actions that were taken were, something that was against the city ordinance. Okay, we all live by ordinances. That's how we all have to get along and kind of, live happily ever after. But I will say that dogs, cats, birds, fish, gerbils, squirrels are all lovable, engaging, just, something that everyone needs in their life, whether it be a four-legged, a two-legged, a no-legged, it doesn't matter. It's something that everybody decides for their own reasons, for their own family, what's good for them and what's not. So I'm sure that, the choice that you all are going to have to make will not be an easy one. And I hope that you all can do it, reasonably and precisely, and do it when you see the evidence, when you see everything that's been listed, said, done, viewed, that you put all together, and you can make the final decision and the right decision. Because ultimately, I would think that, we're all very reasonable around here. And like keep level heads and understand that issues do come up. Neighbors have issues all the time, sometimes. And unfortunately, our pets get involved in those issues. However, the declaration that was placed on my dogs, I believe was unjust. And it's up to you all to understand that it's your duty to review the evidence and come back with the guilty or not guilty verdict, whichever you see as fit. All right. Thank you.
Okay, ladies and gentlemen, we're gonna ask that you would, follow the bailiff into the hallway. We may call some of you back in for some follow-up questions. At this time, everyone please stand as the panel exit the courtroom. Y'all can go either, well, y'all can go out either side. We have two doors.